let's talk about some of the potential nominees that President Trump is considering. So according to Fred Barnes over at the Weekly Standard, the White House has now narrowed down its list of potential Supreme Court nominees to a top 5. Brett Kavanaugh, who's 53 on the D.C. Circuit Court of Appeals, Amul Thapar, who is 49 on the 6th Circuit, Amy Barrett, who's 46 on the 7th Circuit, Thomas Hardiman, 52 on the 3rd Circuit, and Raymond Kethledge, 51 on the 6th Circuit. So all of these folks are relatively young. You figure that all of them will spend probably 30 years on the court, barring serious health problems. This is why the idea that Trump gets to shape the court for a full generation here is exactly right. Now, all of that assumes, of course, that Chief Justice Roberts isn't going to become a Kennedy-like swing vote, which I think is a dubious assumption, but it's possible that you may actually have a conservative majority on the Supreme Court for the first time in legitimately generations. So here is what we know about the people who are being discussed. Brett Kavanaugh is apparently the front runner. He is also the person who is the most icy. Okay, so I do not think the president should select Brett Kavanaugh of the D.C. Circuit Court of Appeals. He's a former clerk for Justice Kennedy. He was elevated to the federal bench in 2006 after a 3-year delay. The reason his nomination was delayed was because Democrats were upset over the fact that Kavanaugh used to work for Ken Starr in the office of the Solicitor General, and he had the temerity to say that the Clinton administration targeted Ken Starr. So Kavanaugh has been on the court for quite a while. He has a long record. He's authored about 300 decisions. He recently dissented when the circuit decided that a 17-year-old illegal immigrant detainee had a right to an abortion. He said that the decision was, quote, based on a constitutional principle as novel as it is wrong. He held in 2011 that the Washington, D.C. ban on semi-automatic rifles and its gun registration requirement were unconstitutional under the Supreme Court's Heller decision, which recognized that the Second Amendment to the Constitution was an individual right. All of these are good decisions. He also held that the Consumer Financial Protection Bureau structure was unconstitutional, which of course is true as well, and holds administrative decision-making to a minimum. Okay, Kavanaugh, here's where it starts to get a little bit dicey. Kavanaugh, like Chief Justice Roberts, is known for working across the aisle. He is, on the downside, apparently, a general believer in Chevron deference. Chevron deference is the idea that you have these administrative courts, these administrative law courts, that get to decide your fate, and you can't appeal that directly to the judiciary. So administrative law courts exist in the executive branch. There's a whole branch of thought that says Chevron deference is stupid, that if something is decided by, for example, the EPA, that is reviewable by a judge because the EPA is not a judicial system. The EPA is a regulatory system. Kavanaugh reportedly does not use textualist methods nearly as much as conservatives might wish, and worst, he upheld Obamacare in Sissel versus Department of Health and Human Services, as well as Seven Sky versus Holder, in which he may have actually crafted the rationale that Chief Justice Roberts eventually used in calling the Obamacare penalties a tax. Remember that Chief Justice Roberts rewrote Obamacare to make it constitutional, suggesting that it was a tax rather than a penalty. And it appears that Kavanaugh may have actually created that rationale. So I'm not saying that Kavanaugh would certainly be another Chief Justice Roberts, but I think it's more likely he would be another Roberts than another Gorsuch. Okay, now Amul Thapar, he's relatively new to the appellate courts. He voted to uphold Ohio's method of lethal injection, and a Michigan government's meetings opening with a Christian prayer. He said that's legal as well. He's ruled that monetary donations are a form of protected speech under the First Amendment. Now, because Thapar's record is relatively thin on the Court of Appeals, he's only appointed in the last year and a half, there's not much to go on with regard to issues like abortion and religious freedom. With that said, Professor Brian Fitzpatrick of Vanderbilt Law School described Thapar as very Scalia-like and very Thomas-like, and Thapar has criticized Richard Posner's pragmatism. Posner is on the Seventh Circuit Court of Appeals and is a terrible judge. He criticized Posner's pragmatism in judicial theory because using pragmatism rather than text would, quote, elevate judges to the position of co-legislator, which is exactly right. Judges should not be legislating. They should be interpreting the law as it is written. He is a textualist who has praised Scalia himself. So if I have to choose between Thapar and Kavanaugh, I choose Thapar. The best of the bunch, it seems to me, is Amy Barrett.